Hello, and welcome to the View from Mayor Brown podcast. This is a fortnightly podcast series for employment lawyers and HR practitioners, which highlights developments in case law and legislative changes of importance to UK employers. It is presented by Nicholas Robertson, the head of Mayor Brown's London employment team. The time spent listening to these podcasts can count towards your training requirements. At the end of the podcast, we will explain how to get in touch if you have any comments or questions.
Hello and welcome to podcast number 124. We're back to the normal format of 3 cases. The first case, it's to do with whistleblowing, which for my money is one of the most complex areas and also potentially for employers, one of the most troubling at the moment. The case concerns how the courts should react if the dismissing manager is innocent of any wrongdoing, but has relied on evidence from a potentially malicious work colleague in coming to the decision to dismiss. Secondly, we've got a case on risk assessments and breastfeeding, and I think the case is going to cause employers to look again at their procedures fairly closely for doing risk assessments. And finally, we've got a case on the interplay between various protected categories of employee. In this case, it's the right of individuals to practice their religious beliefs, coupled with the rights of those protected groups who may take offence at some of the religious teachings. As always, you can access the podcast via iTunes, the Mayor Brown website or YouTube, and the Twitter feed where the handle is Nicholas Robert, ROBER11. And that's where we have the links to the cases that we're discussing. So first up, Royal Mail Limited and Jutti. I think the law related to whistleblowing, as I say, is one of the most complicated areas of employment law at the moment. Partly this is because of the high stakes that come with a whistleblowing claim. However, additionally, the law in this area is continuing to develop, and sometimes it's in quite surprising directions. I think it's worth spending a little bit of time on this case because of the potential implications. Let's start with the facts. The claimant was recruited to work for the Royal Mail. Her immediate line manager was a Mr. Widmer. The facts are complicated. I can only give a brief summary. But in essence, early on in the employment relationship, she reported some potential regulatory breaches to Mr. Widmer. But in the face of a hostile response from him, she withdrew the allegations and wrote an email or a letter indicating that she was mistaken. Her relationship with Mr. Widmer then deteriorated, and she ended up being signed off with stress. Some months later, a manager was appointed who had no previous involvement with the claimant to consider whether to terminate her employment on the grounds of her unsatisfactory performance. Although reference was made in the disciplinary process to the claimant's whistleblowing allegations, Mr. Widmer did not disclose to the disciplining manager the full impact of what had happened, and so the disciplining manager, genuinely and reasonably, in ignorance of the whistleblowing allegations, dismissed the claimant. The primary issue, by the time the case gets to the Court of Appeal, is whether the disciplining manager's innocence of any wrongdoing absolved the company of liability for the fact that a decision to dismiss had been taken on the basis of Mr. Widmer's actions, which were found to be motivated by the protected disclosures which the claimant had made. It was found that Mr. Widmer's actions, malicious actions, made it inevitable that the claimant would be dismissed. The claimant brought claims saying she'd been subjected to an unlawful detriment, contrary to Section 47B of the Employment Rights Act, 1996, and that his dismissal was automatically unfair, contrary to Section 103A, i.e. because she was dismissed for whistleblowing. These two sections raise different issues, and it's important to deal with each in turn. Let's start with Section 103A, the dismissal section. This says that an employee is treated as being unfairly dismissed if the reason, quote, or if more than one, the principal reason, unquote, for dismissal, is that the employee made the protected disclosure. So, here, was the employer treated as having dismissed the employee because of the actions of the dismissing manager alone, based on what she knew, or was the employer deemed to have dismissed based also on Mr. Widmer's knowledge and actions? On this point, the Court of Appeal came to a clear decision. And it's one which is helpful to the employer. They looked at the test in ordinary unfair dismissal cases. What sort of knowledge is to be treated as the knowledge of the employer when dismissing? Remember that here, the dismissing manager both genuinely and reasonably believed that the claimant should be dismissed for poor performance. She was misled, but genuinely and reasonably so. The Court of Appeal accepted that when identifying what the reason for dismissal was under the ordinary unfair dismissal test, the Employment Tribunal looked only at the mental processes of the person or persons who were authorised to and did take the decision to dismiss. Although the claimant here tried to argue that a wider test should be applied when it came to protecting whistleblowers, the court did not accept that. Court of Appeal went on to give some guidance about the circumstances in which a malicious agent, who was not the person taking the decision to dismiss, could nonetheless be treated as acting on behalf of the employer. For example, if you had a malicious colleague who had no relevant managerial responsibility for the disciplinary process, e.g., although presenting false evidence to the process, that knowledge would not be attributed to the employer. The employer, in those circumstances, under Section 103A, has not acted unlawfully. Secondly, if the malicious colleague is the victim's line manager but does not have responsibility for dismissal, then again, this knowledge is not attributed to the employer. The Court of Appeal considered, however, there would be a strong case for treating the employer as having the knowledge if the malicious colleague conducted the investigation process, even if they weren't actually part of the dismissal itself. This point was not formally decided, but the Court of Appeal could see different arguments. They also left open the situation where someone at the top of the tree, i.e. the CEO, for example, procured someone's dismissal, even if the disciplining manager didn't know what was going on and the disciplining manager wasn't the CEO. They said again the CEO's knowledge might be capable of being attributed to the employer. So on that basis, the Court of Appeal were clear the employee's claim under Section 103A failed. The disciplining manager had acted genuinely and reasonably, but in ignorance of the malicious colleague's actions, and unfair dismissal requires unfairness on the part of the employer. However, this left the claimant with the claim under Section 47B of the Employment Rights Act. And this is the basic right that the worker or employee has a right not to be subjected to any detriment by any act or deliberate failure to act by the employer done on the ground that the employee has made a protected disclosure. Now, this expressly covers actions. The detriment provisions expressly cover detriment imposed by other workers in the course of their employment if they are effectively retaliating against the whistleblower. If a worker in the course of employment subjects a whistleblower to a detriment, that's deemed to be the act of the worker's employer unless the employer took all reasonable steps to prevent such detriment happening. I think there are two key points to appreciate up front. First, the test for liability is not the same as the test under Section 103A. Under Section 103A, the employer can only be liable if the reason or principal reason for dismissal is the employee's whistleblowing. Under Section 47B, however, the desire to retaliate against the whistleblower only needs to be a material part of the decision. It does not need to be the principal reason. Therefore, it's easier to show a detriment claim under Section 47B than it is to show a dismissal claim under Section 103A. However, there is a further complication. Section 47B claims are not available if the worker is an employee and the relevant detriment amounts to a dismissal. This is provided in the statute. In other words, at first blush, if you dismiss an employee, that dismissal claim has to be brought as a Section 103A claim, cannot be brought as a Section 47B claim. Here, in essence, the employee claimed that Mr. Widmer's actions were a detriment contrary to Section 47B. This inevitably brought about her dismissal, and as such, it was alleged, it was possible to claim under Section 47B for the damages flowing from the dismissal, even though it was not possible, the Court of Appeal had found, for her to claim for the dismissal itself under Section 103A. Slightly frustratingly, having teed all that up, we don't have a clear answer on that. The Royal Mail took the view that because of the way the claimant's claim had been pleaded, it was not possible for the claimant to bring a claim based on this point to the Court of Appeal, and this was rejected by the Court of Appeal. Therefore, the Court of Appeal did not address the argument that Section 47B brackets 2 brackets, the dismissal exclusion I mentioned, precluded this route being taken by a claimant. The Court indicated they did not wish to express a view as to whether or not Section 47B brackets 2 necessarily included a detriment claim where the damages were the wages flowing from dismissal. They acknowledged this was a difficult issue. They indicated it was possible to argue that the detriment, covered by Section 47B, was Mr. Widmer's wrongful actions, and the dismissal was a consequence of that detriment, i.e., the detriment was not the dismissal itself, and therefore Section 47B did not preclude damages for a detriment, including the loss of job. Nonetheless, the Court of Appeal indicated it was also aware of the fact there was another case coming up called International Petroleum Limited and Osipov. In that case, and I suspect we're going to be coming back to Osipov, the EAT accepted that claims could be brought directly against individuals who had brought about the unlawful dismissal of a whistleblower. In that case, a very substantial damages award was made against the individuals who were found to have procured the dismissal by the company of a whistleblower. If you put that decision together with this, with the suggestion that it's easier to claim damages for detrimental treatment than it is to claim damages for dismissal, with the argument that the detriment can cover losses caused by the subsequent dismissal, then you'll be extending whistleblowing law quite significantly, both against the range of defenders and in terms of what they could be sued for. Either way, I'm convinced that many more whistleblowing claims will now include claims under Section 47B to the effect that there has been a detriment caused to the employee. The claims will add in individuals as well, who it is said are guilty of wrongful actions towards the claimant. This will be done partly to increase the pressure on the employer, and partly because individuals will see the possibility of getting or proving damages claims against managers, colleagues, etc. under Section 47B as being an easier route to success and offering no lesser remedy than the obvious route under Section 103A. Of course, remains to be seen whether the Court of Appeal, assuming that the appeal in Osipov continues to the Court of Appeal, agree with the idea that whistleblowing damages for dismissal can be awarded against individuals. Equally, employers dealing with disciplinary hearings where there are whistleblowing allegations may need to proceed carefully. It may make sense in some cases to isolate the decision makers so that the decision is taken genuinely and reasonably in ignorance of the whistleblowing allegations. However, if there is linkage between the allegations so that the whistleblowing allegations feed into the grounds that the employer is considering using to rely on to, for example, dismiss the individual, it may make sense to ensure that the disciplinary manager fully knows about the allegations so these can be taken into account and fully investigated. So, that's the case of Royal Mail Limited and Juti. Next up, Trahorn and the Secretary of State for Justice. This is an EAT case dealing with a claim for religious discrimination. And speaking personally, I always find that the intersection between different protected status individuals to be interesting and potentially quite controversial. Here we have an individual's right to follow a particular religion and manifest those beliefs, bumping into people who reasonably took offence at some of the comments he made based on those beliefs. In brief, the claim arose out of church services being held at a prison. Mr. Trahorn is a Pentecostal Christian and an ordained minister. He spoke during one church service about why same-sex marriage was wrong. This resulted in him being instructed by the prison not to preach at the prison chapel in future. Then a couple of months later he was leading the singing, which he was permitted to do, and he felt compelled, he said, to share some verses from the Bible about repentance from sin. Included in his comments were comments that were subsequently decided to be homophobic. Unsurprisingly, there were complaints arising out of Mr. Trahorn's comments, and he was then told he could no longer volunteer to take part in the services at all. He issued a tribunal claim asserting direct and indirect discrimination based on religion or belief. The indirect discrimination claim is the one I want to focus on. There were two aspects to this case that were of interest. The Employment Tribunal rejected his claim and did so for two reasons. The first I want to focus on is the chapel's treatment of him and whether that was justified. Obviously, under indirect discrimination, even if there is an indirectly discriminatory provision, criterion or practice, PCP, this can be justified. And I'm slightly starting at the end here, but I just want to focus on justification for a moment. Justification requires the chapel to show the treatment was a proportionate means of achieving a legitimate aim. The tribunal said the legitimate aim here was connected with retaining order in the prison and protecting prisoners within the prison environment. The claimant's rights were minimally restricted by the instruction given not to participate in services. It was instruction that only applied within the confines of the prison. In any event, in the view of the tribunal, it only prevented him from, quote, the insensitive manifestation of his beliefs within the prison and the chapel. So, legitimate aim, minimal interference, therefore this was all justified. And for me, this is the more interesting part of the claim. The prison's actions were motivated by clearly sensible and legitimate motives. In general terms, Mr. Trahorn was free to hold and manifest his views, but this didn't give him a licence to act in a way that was potentially dangerous for the other inmates or reasonably offensive to them and their reasonable interests. Although the particular facts in this case and the context in which it arose, a prison, meant that issues of safety and protection for prisoners were unusual, the point is that Mr. Trahorn had no absolute right to make whatever statements he saw fit about same-sex marriage, irrespective of the fact that these were manifestations of his undoubtedly genuinely held views. Second aspect of this case was the Employment Tribunal rejected his claim on the grounds that he had not shown either individually or on a group basis, that there was a detriment to those holding his beliefs. There were two PCPs. One was that there was a policy dealing with conduct in the prison, in the chapel, and the other dealing with equality issues in the prison. And these policies underlay the basis for the prison's decision to discipline the claimant. He alleged that the conduct and equality policies put Christians, or Pentecostal Christians, at a disadvantage because they were more likely to breach them because of their beliefs. The tribunal decided, having heard all the evidence, that there was no evidence as to innately why Christians or Pentecostal Christians would be disadvantaged, either on a group or an individual basis. Accordingly, the claim for indirect discrimination also failed on that basis, and this approach was upheld by the EAT. There was an attempt by Mr. Trahorn to argue it was no longer necessary under English law to establish that there was a group disadvantage in that the PCP adversely affected a particular group of individuals. Well, the EAT took an orthodox route of indicating there was a need to show group or individual disadvantage, but it was a relatively low hurdle. It's enough to show that some individuals sharing the claimant's religious beliefs would have taken the same view as the claimant, but there was no evidence of any sort of group impact whatsoever, and therefore the claim had to fail. All in all, therefore, I think the message is exactly what one would have expected. If you have individuals who are taking offence at statements by others, perhaps statements made on religious belief grounds, for example, employers should adopt a common sense approach. It's not necessary to determine that one type of protection trumps another type of protection. Equally, an employer who is worried about the reaction of, for example, an individual in a same-sex marriage to adverse comments made by someone who's a religious adherent may be able to, and indeed may be expected to, take steps to safeguard that individual's interests when faced with the employee espousing religious and hostile views, but which can be curbed in a way which has a minimal impact on that person's religious views. Anyway, that's the case of Trahorn and the Secretary of State for Justice. Final one, Ramos and Servicio Gallego de Saude, and I do apologise for my pronunciation. This is an ECJ case dealing with workplace risk assessment. It's slightly off the beaten path for us, but I think the point that he makes is both a succinct one and a really important one. As you'll have undoubtedly worked out from my pronunciation and an intimate knowledge of Spanish, the claimant is a nurse at a Spanish hospital. She went back to work whilst she was still breastfeeding and notified her employer that she was concerned about the potential health impact of her place of work on her ability to breastfeed. Part of this was to do with the shift system she was working under, and partly she was worried about exposure to some types of radiation and stress issues. She wanted adjustments to be made to alleviate these potential adverse effects. The hospital didn't accept this and issued a report that rejected her request. When the hospital turned her down, she applied for what looks to be like a social security benefit in Spain, paid to mothers who are breastfeeding but who are at risk at work. When this was turned down, she sued, and the matter went up to the European Court. Relevant legislation is the Pregnant Workers Directive, which requires member states to protect breastfeeding mothers. This protection is to be based on a risk assessment which is to be carried out by employers where there is potential risk to a breastfeeding worker. There is a list of relevant risks to be considered. Here, the ECJ decided there had not been a suitable workplace risk assessment, and this amounted, if it was made out, I should say, to less favourable treatment of a woman in connection with pregnancy or maternity leave, and therefore it amounted to direct sex discrimination. In order for there to be a compliant risk assessment, there had to be an examination of the specific circumstances applicable to the specific individual in relation to that specific job. Generalised assertions would not suffice. The ECJ pointed out that it was up to the Spanish court to decide here whether or not there had been a sufficient workplace risk assessment, but given that the employee's own manager supported her claim, it's obvious the hospital is going to face a bit of an uphill struggle. And, reading between the lines, it looks as if the hospital had relied on general assertions about work either generally at the hospital or nursing work generally, and had not focused on this job, this individual, and this hospital. The reason I wanted to mention this case, I think it increases the protection for pregnant workers and workers returning from maternity absence. If the employer fails to carry out a sufficient work assessment, that amounts to direct sex discrimination. It is not possible to justify direct sex discrimination, so the employer may have excellent reasons why it didn't do a sufficient workplace assessment, but I don't think that's going to be a defence, and it might be of relevance, I suppose, in relation to damages, but it's not going to be of any relevance in relation to liability. The assessment has to cover both the particular role being done and the particular individual. So employers are going to have to be much more rigorous and undertake far more tests directly than previously thought necessary. Another point to be aware of, this would appear to indicate that the English law approach on breastfeeding claims could be wrong. The Equality Act 2010 provides that a woman cannot claim direct sex discrimination where she is subjected to less favourable treatment because she is breastfeeding at work. It's not clear quite how that statutory prohibition under the Equality Act can survive the Ramos case. Anyway, that's Ramos and Servicio Galego de Saúde. Gosh, it almost trips off the tongue now. And breastfeeding risk assessments. So thank you very much indeed for listening to the podcast. We will be doing a podcast again in another couple of weeks. And as always, it only remains for me to confirm that no employees were harmed or mistreated in any way in the making of this podcast. Thank you very much for listening.
So that was our latest podcast. We hope you found it useful. If you have any questions or comments, please email Nick on nrobertson@mayorbrown.com. Our podcasts are an overview of cases. How the law applies in any particular case will obviously depend on the individual circumstances. So please take legal advice if any of the matters discussed are relevant to issues that you are dealing with. And thank you for listening.